All right, welcome back to the Expert Witness Podcast. I'm here today with Nigel Jones, who has been an expert witness on over 100 cases, has been deposed 44 times and testified in court 11 times. He has a bachelor's degree in mechanical and electrical engineering and has 6 people that work for him constantly. So Nigel, thank you for being here. We're excited to hear about your experience and learn from you today.
Thank you. It's good to be here.
All right. So the first question I always like to ask is, expert witness work is an interesting field. It's not one that you really hear about as you're growing up. So I'm always curious, how did you find out about expert witness work and how did you really get into it? Where did you get your start in this industry?
So obviously, like everybody, I suppose I'd seen news reports about expert witnesses, but they were typically in the terms of, medical malpractice and those sorts of things. I'd never really seen much in the way of engineering and expert witnesses. Then I learned some more from a good friend of mine who was an attorney who did actually use engineers as expert witnesses in his work. But the way I actually got my start was perhaps a little unusual in that, almost 15, maybe more years ago, DirecTV, the well-known satellite TV provider, was completely hacked. That is, you could go onto the internet, such as it existed then, and purchase devices that would allow you to effectively receive DirecTV for free. And this was very widespread. And DirecTV did something very unusual. Normally, in these sorts of situations, they just go after the people that provide the gizmos, if you will, that allow you to steal stuff. And they did do that. And when they went after one of these very large providers, they acquired this company's customer list. So everybody that they had sold these devices to. And DirecTV turned around and sued every individual.
Oh, wow.
Yeah, this was very controversial because essentially DirecTV sent out a demand notice to these people saying, pay us, I forget how much it was, of the order of $3,000-$4,000, and we'll make this go away. If you don't pay up, we're going to take you to court. Very controversial, and lots and lots of people opted not to pay up. Thousands of people individually. Caused a bit of an uproar in the federal court system, as you can imagine. But as a result of that, DirecTV needed engineers that could analyze these devices, write reports on them, and if necessary, testify. So a friend of mine who I'd done some work for at the time happened to have a fairly prominent place in the industry, and he got contacted to act as the expert witness, and he ultimately brought me in to help out to analyze these various devices. And so that was my first exposure to expert witness work. I did not do any testifying, I just did some analysis of these various devices, wrote reports, and so on. And then I suppose what happened next was, fast forward a year or two, and DirecTV got sued by effectively Dish Network. Well, I say DirecTV, excuse me, not DirecTV. DirecTV's smart card supplier. So in satellite receivers and cable receivers, there is a smart card in there, referred to as a conditional access module, which says which channels you're entitled to receive and so on.
Mm-hmm.
So Dish Network sued the conditional access supplier for DirecTV, saying that this conditional access supplier had deliberately hacked Dish Network in order to protect their marketplace and promulgated the hack on the internet. And, so the conditional access supplier spoke to DirecTV. DirecTV suggested that they speak to us, and we got involved in that matter. And we divvied up the work between three of us. And it so happened that the portion I got ended up being the relevant portion. The other two guys' work proved to be nothing of significance.
Mm-hmm.
And so the next thing I knew, I was the testifying expert in a multi-billion-dollar lawsuit. So that's how I got my start.
All right, thrown into the deep end on that one.
Yes.
Very good. That's interesting. So at that time, were you doing engineering work on your own before you got into doing the expert work? Did you have your own company, or were you working for another company in the industry, or how did that work?
Yeah, I was able to do that because at this point I had my own well-established engineering consulting firm. So I was doing mainly design work for people, designing circuits, writing code, doing some reverse engineering, this sort of thing. And so the work was a fairly natural fit for me. It was devices that I understood and so on. But perhaps, there's an interesting codicil to this, which perhaps your listeners will be interested in, David. If you think about it, you say, well, that's a fairly niche marketplace, right? I mean, how often do conditional access system providers sue each other? So as part of this lawsuit, I became really familiar with the different forms of satellite TV piracy. And it turned out that the piracy that was at issue in this lawsuit was no longer really germane. Right? The marketplace had moved on. And I might add as well that I was working for the defendant. We were completely successful in defending the allegations against us. And as you can imagine, I wasn't very popular with Dish Network.
Mm-hmm.
But as part of my work on this case, I began to understand the prevalent forms of piracy. And so after the case was over and the 1-year mark had elapsed, which is the sort of time for appeals and so on, I actually contacted the attorneys for Dish Network. These are the guys that had cross-examined me at trial,
Mm-hmm.
with the permission of DirecTV, I might add. But I contacted them and I said to them, I said, hey, this new form of piracy that you're dealing with, which are called free-to-air receivers, I said, I think I can prove that these devices are designed explicitly for piracy. Needless to say, they were a little bit surprised to hear from me since I've been on this. And they didn't believe me. They said, we've looked at it. No, you can't show that. So I think I can. So they retained me. They just gave me a small retention agreement and said, here, look at this thing and tell us why you think it's designed for piracy. And I did. And they were pleasantly surprised at what I came up with. And the next thing I knew, I was retained by Dish Network in 24 different piracy cases over the next 5 years, analyzing these devices and showing that they were used for piracy. And I work for Dish Network to this day.
Wow.
Yeah.
That's great. That's a probably an uncommon way of getting new cases, but sounds like it really paid off for you to do that work and make that leap.
Yeah, absolutely it did. So that was perhaps not something you come across every day in the expert field.
Absolutely. So when we were talking earlier, you had mentioned that you just have a bachelor's degree. Is that right? You don't have a master's or a PhD. Has that ever been a problem for you or an obstacle in any way?
Yes and no. So one thing I have observed over the years, nobody has ever hired me based on my CV.
Mm-hmm.
I have run into plenty of lawyers and law firms whose view is if you do not have a doctorate, you can't possibly be an expert witness. Well, that's not true. All of my work has really come through word of mouth. So it's definitely difficult if you do not have a PhD. So, for example, many expert witnesses get most of their work through expert search agencies.
Mm-hmm.
Out of 100+ cases I've worked on, I have done precisely one case via search firm. And I think that's in large part because I do not have a PhD.
Mm-hmm.
So.
Oh, that's interesting. I do find that most of the experts that are on the other side of cases that I work on do have a PhD most of the time, but I have a master's degree, and my mentor, if you will, just has a bachelor's degree too, and he's done, 500, 600, 700 cases over the years. So it's not required for sure, but it can be helpful to get you into the industry, or at least, get you over those first hurdles in getting retained, I think.
Yes, absolutely. And I have observed, if you will, one advantage to not having a PhD is that when you get in front of a jury, I think it's possible that some jurors think you're more relatable. So if your opposing expert is, a university professor who spends an hour talking about all of his qualifications and his books and journal papers and PhD students, and then it's your turn, and you say, "Well, I'm an engineer. I actually design things for a living." It's a very marked contrast.
It is, yeah. You're the man in the arena, if you're familiar with that quote. So,
I'm not, but I think I get the gist of it. So
yeah. All right. So, can you tell us a little bit more about what types of cases you commonly work on? I know initially you started out with, satellite TV and Dish Network. Is that still the case, or where has this trip taken you, so to speak?
yes, so although the TV piracy thing is still part of my work, it's now a relatively small part. I now work pretty much exclusively in the intellectual property space. So that's obviously still copyright infringement and piracy, but now I mainly work in the area of patents.
Mm-hmm.
And the way that came about is that I have very good software skills, and I have a very good understanding of hardware. And so I was asked to examine the software that go into various things.
Mm-hmm.
And it started becoming apparent to the various law firms that I was really very good at doing this. And such that I was ultimately asked to analyze the software in a cellular base station. This would have been around 2010, I suppose, 2009, 2010 timeframe. And this was a completely new world to me. I had to do a tremendous amount of reading and very rapidly get up to speed on cellular technology. I already had some background in telecommunications, so it wasn't like I was into a completely new field, but the specifics, particularly of what LTE as it was coming out then, was new. And anyway, I rapidly did one LTE case after another to the point now where I am currently retained on close to 10 cellular cases. And I'm typically retained by many of the really big players in the cellular industry. So I do a lot of work in that space now as well.
Okay. And, and so we actually met working on a patent case that involved some mechanical issues and some software issues, back a year or so ago. And so for a lot of people, different types of expert witnesses have different roles in the cases, and sometimes those roles are smaller, sometimes those roles are larger. So for these patent type cases, is that typically a pretty small role, or is that a pretty big role requiring a lot of time and effort and work on your part?
It's a very interesting question, David. So I would say, in a typical patent case, I am probably 75% of the time retained purely to do source code, examine the software of devices. The other 25% of the time, I'm also doing either infringement or non-infringement. And so typically source code review and understanding the patents and so on is a much bigger job than doing infringement or non-infringement. It just takes a lot of time to study the source code and work out how products work, and then map that onto claim terms. And so it will not be unusual for me and my team together to spend 200-300 hours on a case. And then at trial, I may only be on the stand for 30 minutes, whereas the infringement expert may be on the stand for 4 or 5 hours. But the infringement experts involved in the case prior to testifying might have been just 40 or 50 hours. So it really depends whether you're looking at it in terms of the work before trial or the work at trial.
Oh, that's great. Yeah, patent cases, there's just a lot of work that goes into those from all sides. I think, a lot of experts will work, 5, 10, 15 hours on a case, and that for a patent case, that would just not really even get you started. So very good. And so you'd mentioned that you have a team of people that you work with. Can you talk to me a little bit about that, how you do that and why you do that?
Yes. So I've got 6 individuals who regularly work for me, and by regularly I mean every month they send me invoices for anything from 25 to 150 hours kind of numbers every month. Why do I do that? Multiple reasons. The first is there's just too much work for me to do. Number two, I've been very fortunate that the group of individuals that work with me are all really smart engineers. They've all basically started their own consulting businesses over the years, which means that they're good enough to stand on their own 2 feet right off the bat. And the other aspect is they bring a diverse skill set. So, for example, let's say hypothetically I was approached about a patent case involving, say, PCI Express. Personally, I don't know anything about PCI Express, right? I guarantee you one of my guys does. So that allows me to have someone on the team who can very quickly get up to speed on a patent case and quickly provide input to the attorneys in terms of whether the patent reads are good, bad, or indifferent. So to summarize, I need the help, really smart, and they've got good breadth, a much broader range of knowledge and experience.
All right. Yeah, that's great. A good way to provide more value and get more work done. So I've heard that there's an unwritten rule in the legal industry, says something to the effect of everything will be due at the same time. I don't know if you've ever run into that, working on all of these cases that you have. But have you had that experience where you have 2 or 3 reports due the same week, or 2 trials or depositions back to back? Is that something that you run into, and how do you handle that?
Yeah. So here we are in, was it the 26th of October when we were recording this? So I was originally scheduled to have 4 trials this month, and 2 of those trials were at the same time. And then of those 4 trials, 2 got moved within the month to overlap again. And it is a nightmare. Scheduling is very difficult. And you are at the vagaries of the court scheduling. So even when the court says, the trial date will be such and such, they can and do just move them very often at extremely short notice. So that is a huge problem. Having a team of people makes it much more manageable. If it was just me, it would be impossible.
Yeah, absolutely. All right. So what is it that you find enjoyable about expert work? Why do you keep doing this sort of thing?
So to me, there's, I suppose, several aspects to it. One is the intellectual challenge. It can be very, very challenging intellectually to grasp what is going on. And you've got to do it quickly, all right? It's not like you can go ahead and take 3 years to get up to speed on sort of certain technologies. So intellectually very challenging, not just from a technical perspective, but also sometimes from a legal perspective. So, for example, on a patent case, if you're working for the defense, truly understanding the patent claims and terms and seeing if there are weaknesses in those claims. It's a very intellectually challenging exercise.
Mm-hmm.
So that aspect of it. I've also always enjoyed teaching, really explaining difficult technical concepts to people. And that's the way I view testifying to a jury.
Mm-hmm.
Is you're explaining to lay people really complicated concepts and doing it in a way that hopefully they can understand what you're talking about. And I find that aspect of the work.
Yeah, absolutely. It takes a special skill set to be able to do that, to be able to relate the complicated engineering principles to people that just don't interact with that on a day-to-day basis. So it is a challenge, and it's fun to see that light bulb click in their head when you're talking about it, when they finally grasp what's going on.
Absolutely.
Very good. So kind of on the opposite side of that, no job is perfect. What are some things that are frustrating or annoying or difficult about doing expert witness work?
You've actually alluded to it. The biggest issue is scheduling. I'll give you an example. One of the 4 trials that I was supposed to have in October got arbitrarily moved to the middle of November, slap bang in the middle of a long scheduled vacation.
Mm.
And that is very annoying, not just for me, but for the other people involved.
Absolutely.
And so, the scheduling and the time pressures of some cases can make it difficult to do the job you want to do. If you've got a task that is a 100-hour task and you're being required to do it in 10 hours, then it's a problem. So I'm fortunate now in that I have enough of a relationship with enough law firms that I typically get involved very early on in cases. In fact, on the plaintiff side, it is common for me to be retained before the case has even been filed. And so that really helps to plan time allocation and so on, as opposed to, hey, you need a report and we need it in 2 weeks.
Yeah, been there before, absolutely. All right. So have you ever been reviewing information for a case and found out that you are definitely on the wrong side? And if you have, what did you do?
Yeah, so in patent matters, this is a little bit of a difficult one. So for your members who are listening to this who don't understand anything about patents, in general, in patents, there are at least 3-4 different ways to win or lose a patent case. So in general, patents have to be valid, they have to be infringed, they have to have value,
Mm-hmm.
right? And so, for example, if you're working for a defendant and you may look at the patents and say to the client, you infringe, right? You just do. Now, that doesn't mean that the case is over. It just means that from their perspective, if they choose to believe you, that they need to concentrate their defenses on whether the patent is valid and whether it's valuable.
Mm-hmm.
Conversely, when I've been working for plaintiffs, I have gone, looked at defendant systems and reported back to them and said, they don't infringe. And so I had a very, very smart lawyer say to me once, what she said to me was, Nigel, that's not what I want to hear, but it's what I need to hear.
Absolutely.
Which I thought was, yeah, she nailed it. That's the way these things go. So
absolutely. I find most attorneys really appreciate an honest and truthful assessment on things like that. All right. So you've been deposed a number of times and been to trial, and from what people see on TV and stories that they might hear, trials are often viewed as serious and well planned out events. I find that that's not always the case. So have you ever had a particularly lighthearted or funny interaction that happened during a deposition or a trial?
So not during depositions. I was told fairly early on that humor does not come across on a deposition transcript, and it just doesn't. So I can't say I've ever had an amusing deposition. They are extremely dry.
Especially patent ones.
Especially patent ones, right. So in court, a little bit of humor, intentional or otherwise, can certainly go a long way to making the day more palatable for the jury. Mm-hmm. So I can't really say that I've been there where there's been something that has been so earth-shatteringly funny that I could recount it here. But I did witness a lawyer meltdown on the stand. And I wouldn't call it funny, but it was entertaining, at least from us.
Okay.
So I'll set the stage for you. The damages expert for the side I was on had just finished his direct examination and was being crossed. And the cross-examination I thought was very good. I thought it was very effective. The attorney doing it was making some good points and was generally doing very well. And then he said to the expert, "Sir, have you ever had a Daubert motion granted against you?" So, David, do your listeners know what a Daubert motion is? Is that, or do I need to explain what that is?
I would assume that most of them know what that is.
Okay. So our expert said, no. And the attorney said, well, that's just not true, is it? And I know this expert fairly well, and he was quite indignant. It's like, it absolutely is true. You think I'd know if someone had granted a Daubert motion against me. So he then said, well, what about such and such a case? And this was a current case that this expert was working on. And it so happened he was working on that case with the same attorneys that we were at trial with, right? So in other words, Our attorneys knew about this case. He knew about this case. And here he's being accused of having a Daubert motion granted against him. And well, this is no. And so the attorney says, well, and our expert said, and by the way, how would you even know that? Because the Daubert motions in that case were all filed under seal. So how can you possibly know the outcome of these Daubert motions? And you would think at that point, the attorney questioning him, some alarm bells would start going off. But no, he was bound and determined to go forward. And so he said, well, in that case, sir, how do you explain this? And he brings out this piece of paper, and slaps it on the Elmo. And we all look at the Elmo, and it says in clear things, right? Motion to grant sealing of the Daubert motion is granted. So in other words, this poor attorney, I assume some junior associate, had looked at this, had seen the motion to grant the sealing, and interpreted that as motion to actually grant the Daubert, to grant the Daubert motion.
Oh, no.
And you can just see the color drain from the attorney's face as he's reading what he slapped up there. And, you know, needless to say, this was supposed to be his big finish, right? Just the big finish to eviscerate the damages expert. Instead, it blew up in his face. The attorneys on our side jumped up, you know, and just went to town. And to make matters worse, this was literally the last thing of the day. And so the jury was going home, and this attorney had just completely destroyed all the great work he'd done on cross-examination by failing to read this piece of paper. And I just can't tell you that the atmosphere in the courtroom was just one of across everyone. And even the jury was, you know, could understand that this lawyer had just done just incredible faux pas. So yeah, that was one of those interesting times for sure.
Yeah, that does sound like a bad note to leave the jury on, or a good note, depending on what side you're on.
Absolutely.
Oh, that's a great story. All right, so if you were going to give someone who had just been retained for their first case a piece of advice, what advice would you give them?
Yeah, so it's actually a very apropos question, because a couple of members of my team are having their first depositions here fairly soon. And so I give them several pieces of advice. The first one is remarkably straightforward. Tell the truth, right? And to a certain extent, I'm shocked that you even have to say that, but at the end of the day, tell the truth, right? I mean, that's rule number one. And if you can't abide by rule number one, you're in trouble. So, you know, I think that's the first and foremost piece of advice. Secondly, I tell them, do not offer any opinions or whatever that you are not 100% comfortable with. So if you find yourself being pressured by attorneys to take on positions that you don't hold, refuse. The attorneys are not your friends. And so I have seen, unfortunately, some attorneys pressure new experts into taking positions that they have no position taking. And so, sorry, no business taking. So, you know, that's number two. Number three is really, when it comes time for deposition, you need to treat the deposition as if you're preparing for your finals at university. You've got to know your subject matter. And then we can get into all the issues about how you do depositions. But fundamentally, tell the truth. Do not be pressured into taking opinions that you don't really hold, and prepare like crazy for your deposition.
I like it. Very good advice. We find that most experts would like to be involved in more cases. What have you found to be the most effective marketing technique or the best way to get new cases? And we talked about this a little bit earlier, but is there anything else you would add to that?
Yeah, I don't think I'm very typical. As I mentioned, right, I don't get any cases through search firms or whatever. For me, it's entirely word of mouth. So, to a certain extent, it's sort of self-evident. If you do good work, you're likely to get more cases. Um, you can occasionally be proactive. For the story I told about Dish Network, you can be occasionally be proactive. So, but at the end of the day, what does it mean to do good work? I think is really the operative question. And I think in some ways it's obvious what good work is, and otherwise it's not. I've already alluded to the fact telling lawyers what they don't want, they need to hear, but they didn't want to hear, I think is a very big element of doing good work. And the reason I think that really helps with follow-on work. If I tell an attorney, look, you don't have a case here, right? This patent or whatever is, I just don't think they infringe, and here are the reasons. If he comes back to me 6 months later with another matter, and I look at it and I say, I think you've got a really strong case here, he believes me, right? Because he knows that, she knows that I tell them the truth about what I really think, as opposed to what they want to hear. So there's definitely an element of that. I can perhaps also offer another perspective as well. You can think of every deposition as a job interview. So I have been retained by people who have deposed me, I don't know, 7, 8 times now. Okay, they're really unhappy with you in the present matter. But, a year from now, 2 years from now, they've got something else, and they think, who do I know? And oh yeah, Jones, he was a real pain. I need to hire him. And this has been the case. I do work for a lot of the biggest IP law firms, and in almost every case, they were introduced to me as an adverse witness. So if you think about depositions as a job interview, that's not a bad way of building up business as well.
That's true. It's probably an underutilized one. I had a very similar experience earlier this year. I felt it was a really nice compliment after the deposition. It was kind of a weird one. Like, the attorney that had retained me was attended via Zoom, but the attorney who was deposing me came out to Idaho and was deposing me in person. So it was me and that attorney, and then my attorney was on Zoom. And after the deposition was over and my attorney had dropped off, he said, something to the effect of, I hate to say this, but you did a really good job. I hope that we can work together on a different case in the future. So.
Yeah, I had a similar experience. So there was one attorney who was with one of the major IP law firms deposed me for the third time. So 3 different cases he deposed me, and he was a nice guy. And at the end of the third deposition, I turned, we're off the record on words. I turned to him, I said, after a while, we've got to do this with you sitting on the same side of the table as me. Words to that effect. And he's like, yeah, you're right. 6 months later, he hired me. So
good. That's good.
Yeah, it is an effective way.
All right, that's great. So this is an interesting question, maybe a little more personal, but what has adding expert witness work to your offerings done for you and your life and your business? You think it's been a positive addition, negative addition? How has that affected you?
Yeah, I mean, I think in general, it's been positive in the sense that it certainly allowed me to grow the business significantly, and part of the problem I had doing, if you will, regular engineering consulting work is that a typical project would be a multi-year project, which was great. But then when the project was over, then what? So trying to get overlapping projects and continuity was always a challenge. With the legal work, because each case is somewhere between 100 and 400 hours type numbers, you can have much more overlap and continuity and things. So from that perspective, it helps. The downside is the timing and the scheduling required for the legal profession is challenging.
Yeah, understandable. All right, so I guess last question is, how can attorneys find you if they're looking to get in touch?
Yeah, it's interesting. I actually got retained on a case just a few months ago, and it was the first time in 5-6 years that I was actually contacted via my website. I spoke to the attorney. I said, it was interesting because it was a law firm that I'd never worked for before, but which I'd been adverse to on multiple occasions. And so my assumption was that they knew of me from being adverse to them. I was like, no, he was looking for a DMCA expert, and, Digital Millennium Copyright Act. This is all the television stuff I do and things. And so I'm very knowledgeable in that area. So he said, I just Googled DMCA expert and your name came up. So I personally was quite shocked by that. So that does happen once in a while, but typically attorneys find me by word of mouth. It's just the way they do it. They occasionally do it by searching similar cases. But the reality is, in the IP marketplace, the technology as opposed to life sciences side of things, I now know lots of attorneys. I mean, I joked I was doing an ITC evidentiary hearing earlier this year, and I knew half the attorneys in the courtroom. You're like, whoa, this is crazy. So, but I recognize that I'm slightly unusual in that regard.
Mhm. All right. Well, Nigel, thank you. This has been both fun and informative. I appreciate your time. I appreciate you being here with us today.
You're welcome. Thanks for having me.
All right. Take care.